Welcome back to the High Court Report. I'm here today to share some thoughts on oral arguments in Landor versus Department of Corrections and GEO Group versus Menocal. Landor involved lost locks and clipped constitutional claims. GEO Group involved an immunity fast pass to appeal. The court began with Landor. Oral arguments lasted about 1 hour and 50 minutes. GEO Group, the second of the two cases, lasted about 57 minutes. It must have been a marathon day. It must take a moment for the justices to go from one case to the other. Get this, Chief Justice Roberts officially concluded Landor at 11:56 a.m. How long do you think until he called the next case forward? 1 minute. He began GEO Group at 11:57 a.m. That means 1 minute to switch quickly from one major case to another. I'd love to learn more about how they switch gears. I bet they're active writing notes or somehow finding a way to instill their impressions from the first case because they don't have time afterwards to debrief. And when readying for the second case, do you think some of justices start eyeing the second case file while the first one winds down? I imagine they prepare key ideas and questions to help transition, and I imagine the petitioner's opening statement gives them time to orient to the new case. All right, let's talk GEO Group versus Menocal. I want to start there because I plan to end with clips of key moments from Landor. Justice Jackson led all justices with 19 questions. Justice Sotomayor bluntly argued that GEO Group's request about immunity, but simply a question of who should be responsible for that loss. Justice Kagan added to this notion by expressing skepticism to GEO Group's statement that contractors can't price litigation risk into their multi-million-dollar government bids. Justice Kavanaugh delivered perhaps the most damaging line of inquiry, repeatedly asking why the federal government would oppose a doctrine that GEO claims protects government programs, calling this opposition a big hurdle that undermines the contractor's entire argument. Justice Alito countered by comparing contractor immunity to qualified immunity for government officials and asking why the same protective logic shouldn't apply to government contractors. The court heard from 8 justices. I think Justice Gorsuch recused himself because he asked no questions and no one referenced him. 3 primary themes emerged from the questioning: whether Yearsley provides true immunity from suit or merely a defense to liability, the practical implications of requiring contractors to endure lengthy litigation, and the significance of the federal government's opposition to GEO's position. Chief Justice Roberts kept a low profile with minimal participation. All right, let's talk Landor versus Louisiana Department of Corrections. Each advocate got thoroughly interrogated. Oral arguments lasted about 1 hour and 50 minutes. The oral arguments in Landor versus Louisiana Department of Corrections revealed a deeply divided court, grappling with fundamental questions about federal power, religious liberty, and civil rights enforcement. As you recall from prior podcast episodes, this court has no problem achieving a consensus outcome, but with fractured reasoning. That dynamic seemed at play here, with each justice maybe charting their own pathway to decide this case. Justice Gorsuch emerged as the most active questioner, engaging in extensive back-and-forth exchanges that dominated roughly a quarter of the argument time, particularly challenging both sides on notice and consent requirements for individual liability. Justices Sotomayor, Jackson, and Barrett also participated heavily, with Sotomayor and Jackson appearing most sympathetic to Landor's position, while Barrett probed both sides with practical hypotheticals. The conservative justices focused primarily on constitutional boundaries and clear statement requirements, while the liberal justices emphasized the practical necessity of damages remedies and the clarity of statutory text. Justice Thomas concentrated his limited questioning on foundational spending power authority, while Justice Alito asked targeted questions about timing and qualified immunity concepts. Chief Justice Roberts remained largely procedural, though he made pointed observations about legal fictions and contract theory. The argument centered on three major themes that consumed most of the questioning time. First, the court wrestled extensively with contract theory and agency principles, debating whether individual state employees can be bound by spending legislation when they aren't direct recipients of federal funds. Second, justices repeatedly returned to clear statement requirements, with Louisiana arguing Congress must speak with unmistakable clarity before imposing individual liability, while Landor contended the statute already provides crystal clear authorization through its text. Third, the broader implications dominated significant portions of the argument, particularly Justice Gorsuch's hypothetical scenarios about Title IX liability that forced Landor's counsel to admit his theory could dramatically expand individual damages suits across all federal spending programs. These three areas of focus suggest the court views this case as having implications far beyond religious liberty in prisons, potentially reshaping the entire landscape of federal civil rights enforcement. Now let's listen to key clips from the oral arguments that capture these dynamics and give you a sense of how each side fared before the justices.
And in terms of notice and consent, suppose a federal statute said something like this. If a coach at a federal funds receiving university allows biological men on a women's sports team, a female trying to make the team could sue for $1 million. Or an employee of a federal funding recipient in a state agency dealing with family affairs gets an abortion, the father can sue the employee for $1 million. I think on your theory, those are perfectly fine without any particular notice to the individual employee or any particular consent by the employee.
Maybe I can come back to one of the answers I gave before. The rule we're articulating has 4 ingredients. You need to have a valid condition that applies to the person.
Mr. Tripp, where you're winding up is the spending clause is no different than the commerce clause.
I really don't think that's correct, Your Honor, because the crux, the most important condition on the Dole side is you can't have coercion, right? The state needs to go into it eyes wide open, and I believe in your hypotheticals, the person needs to take the job eyes wide open. And so those are very significant checks that mean this is never going to get to the same.
Both of those checks exist in my hypotheticals, and Congress could pass such laws. And that's quite a stretch of the spending clause. We've never before said anything like that.
I mean, if this court wants to cut back on some of the sort of frontline sort of scope, maybe you could do that in some future case, like in the hypotheticals.
I'm not talking about cutting back anything. I'm talking about what 9 circuits have uniformly done since RLUIPA's passage about 30 years ago.
Yeah, and I want to be clear that once Congress, and I'm not going to back down on this at all. Once Congress can impose the condition on the person.
I wouldn't expect you.
Mr. Tripp, how could it have been clear to states when every circuit, as Justice Gorsuch pointed out, every circuit had said that there were not damages actions available against non-recipients under RLUIPA? That's also true under the Title IX context. So it's hard to see how it could be clear to the states that were accepting the money or the prisons accepting the money that it was a clear condition when all of the law went the other way. What would your response to that be?
I think a couple of responses. The first, what this court has demanded every time, and I've said this before, is unambiguous text in light of the context. And this court has never applied any kind of like canon of adverse possession where if the courts of appeals are saying something.
You were a lawyer to the states and that was the state of the law, and the state asks you about that, what would you have said?
I think the key here is to look at the time when the statute was enacted, right? And which is the key question, right, is what did it mean when it was enacted? And if you look at it when it was enacted and you pick it up and you read it, I think as just a state officer working in a federal.
And it's so obvious that every single circuit to look at the question went the other way. It's hard to see how it's clear if every circuit is coming out differently.
And I think this is actually an important point because the prevailing rule in the circuits, including the Fifth Circuit below where this case is coming from, they didn't deny that there was clear notice. They said it would be unconstitutional. because they thought that the officers were like, they treated them as non-recipients, even though they're basically indirect recipients, and it didn't sort of see that they fit within
Well, not every circuit brought up the constitutionality question, but putting that aside, can you identify, putting aside the bribery cases, can you identify any cases in which a non-recipient of funds was held individually liable under a federal statute?
I mean, and I think in Grove City College versus Bell, you're reaching an indirect recipient. In Salinas, Dixon, Hess, and Laudani, those are all situations where you're reaching.
You can just say that, yes, it would be a different factual scenario.
I don't have a case that's on this exact factual scenario. I admit that, but I think actually this is like a lesser included of Salinas, and it's way inside Sabry. I mean, it's nowhere close to that.
But I said put aside the bribery cases. So
if I could push back on that a little bit, I think that's important. When the crux of this program is to provide federal funds to prisons that accommodate religious liberty.
Well, no, I asked you to put them aside because I wanted you to put them aside and look at the civil liability context for a minute. Okay, I think that Sabry and Salinas are the best cases for you, particularly Sabry. I take that. But if those are distinguishable, I wanted to ask you the other question, and I think the answer is no. And I just kind of want to clarify your answer to Justice Gorsuch. Look, the facts of this case are egregious. So if on the facts we were looking for a case in which there should be money damages, this is it. Justice Gorsuch asked you a series of harder facts, harder factual scenarios in which we might think, I'm not sure if money damages as a policy matter make as much sense in that context. You never really gave him an answer, yes or no, and so I just want to say I want you to give me an answer, yes or no, on Justice Gorsuch's hypotheticals, and don't fight the hypothetical about the conditions and all that. Your theory means that, yes, the coach, the doctor could be held liable.
Let me be clear about that.
Yes or no. Yes or no.
The condition.
No. Mr. Tripp, he asked you to assume that the conditions, that it was perfectly consistent with the spending clause. So yes or no, would your theory say that, let's talk about the coach under Title IX, on Justice Gorsuch's hypothetical?
If the condition is valid,
yes. He said all that.
Yes. If the condition attaches, Congress can enforce it. And I think the crux of the question is,
okay, but just say yes or no, yes or no. You don't want to say yes or no. Just take the consequences. It's totally fine if those are the consequences. But I think you have to follow the logic where it leads. And the logic where it leads is that, yes, under Title IX, say, Congress could pass a statute, or Congress could say that it's going to rely on its spending power to hold the coach liable under the hypothetical Justice Gorsuch gave you, right? Yes. Yes.
Now, to be sure, I have a lot of friends on the other side of this case who have valid concerns about Congress's silence over the past 25 years when 10 federal courts of appeals have said that there's no individual capacity claim for damages under RLUIPA. But the solution is not to distort this court's existing precedents to try to change that status quo. It is instead to tell Congress to act exactly like it did in 1993 after Smith and in 2000 after City of Bernie, which is to pass new legislation, supersede SOSAMON, and amend RLUIPA to allow for damages against the states. And then the states can decide, each state for itself, whether it accepts that express condition. The answer is across the street, not here. I welcome the Court's questions.
Do you agree, General Aguilar, that as a spending condition, the federal government could have told Louisiana Department of Corrections that it had to include a clause in the contract telling individuals that they would be liable for damages?
Absolutely, Your Honor.
Why is this so different then?
It's different because, the word privity has been thrown around a lot on the other side of the case, and with all due respect, I don't understand that. When we're talking about consent in the spending context, you're asking whether the ultimate regulated entity has, in fact, consented to whatever the conditions are. And in your hypothetical, Justice Barrett, I think you can conceive of Congress saying, we're going to require you to basically require a contract of assumption by your employees, where anytime an employee comes into the state and says, I want to work for the state says in response, if you're going to do that, you have to agree to these specific conditions that the federal government has imposed on us. There is nothing like that contract in this case, and that's why I think all of those hypotheticals at the end of the blue brief about how Congress could have created direct contractual privity between a state employee in his individual capacity and the federal government doesn't hold up, because at the end of the day, what they're telling you is what Congress could have done. You don't see that line here.
But aren't they saying that if you have the contract and then you have RLUIPA on the books, that the combination of those things essentially is the condition that the employees were aware of?
Your Honor,
when they signed up for the job?
Your Honor, that is not how this Court's spending clause cases conceive of consent. And I think every employee in the country would be shocked to learn that just by accepting employment with their employer, they have thereby personally bound themselves to contracts.
What state remedies did these guards have? This was egregious. Is there a state RLUIPA?
There is, Justice Barrett.
And would that have provided relief to them if they had chosen to sue under it? As far as I can tell, they did not.
They did not sue. Arguably, the answer would be yes, Justice Barrett. At pages 13 and 14 of our bio, we describe our law, which basically mirrors RLUIPA, expressly provides for damages, and, that was available. That's available to all prisoners in Louisiana, and it's available even to non-prisoners in Louisiana.
Well, would the Dole factors be met in that situation?
Well, I don't want to take a position on sort of the outer reaches of the spending clause, because this case is really about enforcement. And so I don't want to get ahead of the United States on very difficult questions about how far does the spending clause go. I think the important thing is that there are limits. The Dole factors, there's the unconstitutional conditions doctrine. Congress can't condition funds on someone giving up their constitutional rights. There's coercion. And then I think the remedy itself has to be constitutional. It has to comply with due process. And then, as I was talking with Justice Barrett about, it also has to be necessary and proper. So there may be some instances in which a remedy is not necessary to enforce a condition or a proper means of enforcing the condition, and those requirements can have teeth.
Well, you're asking us to take an important step. It would be helpful if we had an idea about where this road is leading, but you don't want to provide an answer to that.
Well, Justice Alito, I think because it's not presented in this case. I think that when the court has a spending clause case about how far Congress can go in imposing the condition, then I'm sure we'll be up here as a party talking about that with you. I think that the United States hasn't sort of taken a position on that question because
how often has this court held that Congress has imposed an impermissible condition under the spending clause?
I mean, NFIB is an example.
Yeah. What else?
Alliance for Open Society, there's a First Amendment violation there. There are real limits. I think in Prince said that there was a necessary and proper case, said that it wasn't a proper means of enforcement. So I think that the court can, if it wants, address that in a separate case. I think really the question here, and I'm not trying to frustrate the court, but the question is really just, can Congress enforce a condition that is validly imposed? The hard question in Your Honor's hypothetical is whether Congress can impose the condition, and at page 46, they admit that they are bound by the condition. The only question is one of enforcement, and Congress can certainly, again, if these officers can be held for contempt and subject to personal consequences, Congress can surely hold them accountable in their individual capacity for damages, which everyone knows that is what RLUIPA was trying to do.
Thank you.
When you just said, Ms. Baird, groundbreaking, could you hum a few more bars on that? I mean, groundbreaking how? Groundbreaking what would happen? What would follow?
Sure. Well, I mean, I think Petitioner's brief laid this out nicely, but there's sort of a long history of Congress being able to reach outside of the strict privity between the federal government and an entity that receives funds. I think all of that could be called into question. I think we've cited some sort of on-point statutes in our brief where employees or agents can be held liable. That's the Federal Nursing Home Reform Act, EMTALA, Title X. And then I think if the court accepts respondents' arguments on the constitutional issues, I think that could call into question Section 666, the bribery statutes, and Sabry. I think that this case is such an easy case because this case does not even approach the outer limit that this court has recognized in Sabry as permissible. And I think all the court has to do, the court does not need to extend Salinas and Sabry. I think all it has to do is cite those cases, say that no one has asked us to overrule them.
I take your point that a holding that said that Congress could never pass a statute conditioning employees, making them follow RLUIPA, because that would exceed necessary and proper bounds, would be quite a holding. But the same would go for the coach, too. On the Title IX recipient, there would be quite a holding for us to say Congress couldn't do that. I take that point, but I think it would apply to the coach as well. And I also think it's very different to say whether Congress could or couldn't do it, it didn't provide the clear statement that's required. And there's nothing novel about that. We just did that last year in Medina, for crying out loud, right?
Well, Your Honor.
At the government's urging.
Well,
right?
Your Honor, yes, I think that was right.
All right. And then,
but,
and then we'll go, if you want to finish, you want to add, feel free.
Oh, I was just going to say there's a really important difference between this case and Medina, which I've sort of mentioned a couple times, which is this case involves an express cause of action. So I think in Medina,
I understand that. The question is to whom and whether there's clear notice. And simply saying it's not clear notice and there isn't consent, there's nothing novel about that. We did that in Dole. We've done that in Medina. We've done it, not in Dole, but in a lot of other cases we've done that, right?
I think that's right, but I do think there's clear notice here, Justice Gorsuch.
I understand you think that. No, on the clear notice point, you say, well, it was obvious even before Tansen, right?
Yes, Your Honor.
Counsel, the basis for state liability here is, of course, an agreement with the federal government, right? In other words, they've cut a deal, get the money, and they're going to be have to comply with these conditions. But there was no such arrangement with the defendant in this case, right? They didn't have a direct relationship with the federal government. They didn't get directly any federal financial assistance. So you don't have the same basis for liability as we do in the other typical spending clause case, right?
Right. It's indirect, right? Because the officer and what this court said in Rust is that if a person goes to work for a federally funded program, then they take the job subject to the conditions that Congress has attached to the funds.
You've said many times that this is an easy case, and I think it's because of the privity argument. I'm trying to kind of puzzle through it. The state can say no to the condition in this situation. It has notice. It's a part of the agreement that the state makes to accept the funds, so it can say no to the condition that it must follow RLUIPA. But then we have this other layer, which is the employees, I suppose, can say no to a state that has agreed to the condition. Right?
I think that's right. They have a choice whether to voluntarily accept employment in a federally funded program.
Against the backdrop of a clear cause of action against people in their position for violations of the law.
Yes, I think the statute is clear as day that it applies to individual officers, and in that context, appropriate relief clearly provides
And
damages.
don't we ordinarily hold people responsible, especially officials, for knowing what the law requires and following it?
I think that's generally a presumption that this court has endorsed, yes.
Thank you.
I mean, the surprise that you were saying employees would have, are they surprised to learn that they find themselves subjected to 1983 suits all the time?
Well, Justice Kagan, Section 1983 is a remedy, right? It's a cause of action that gives a remedy. And your earlier question about can't you just do this all under 1983?
I didn't say can't you do. What I'm saying is that your arguments that they're not getting notice, that there's not enough knowledge, I mean, that would just make 1983 suits. The same objections could be held with respect to that, and yet 1983 exists. People bring 1983 suits against state officers all the time, including to enforce statutes that have been enacted pursuant to the spending clause.
That's right, Justice Kagan. And remember that when we're talking about 1983, the antecedent question, at least in the spending clause context, is whether the asserted right under the spending clause legislation is one that can be enforced in 1983. And I think the important point there in that antecedent question is the question we're dealing with in our red brief is, can Congress use the spending clause to create a substantive right that runs against a state official in his personal capacity? And if the answer to that is no, then you never get to Section 1980.
Didn't we answer that question in Tlefsky? I thought we said in the 1983 context that it didn't matter that it was spending clause legislation. We said a law is a law.
We said secured by the laws of the United States include secured by laws enacted pursuant to the spending clause.
That's right. And the question in this case is, does Congress have constitutional authority under its spending clause power to do what petitioners say it did?
No, but I'm saying, why are you not undoing that Tlefsky holding with the argument that you're making today?
Your Honor, because cases like Tlefsky are dealing with suits that are actually against recipients, funding recipients, right? I mean, that's nobody disputes that in the—
That's just a distinction you're bringing in. What I think Justice Kagan was getting at is there's something about your argument that turns on this being spending clause legislation, and that has something to do with the extent to which it can be enforced in this way. And we said in the context of 1983 that it didn't matter that it was spending clause legislation. And what she, I think, is trying to say is, why should it matter here? And if it does matter here, doesn't that imperil the determination that we made in Tlefsky that spending clause legislation should be treated just like any other law for this purpose?
Your Honor, it matters here because of cases like Cummings that trace all the way back to Pennhurst that say the very legitimacy of Congress's exercise of spending clause authority depends on that bilateral agreement. Is it sending money out and taking a reciprocal promise to comply with conditions in? If you're missing that reciprocal consent from a recipient or putative non-recipient.
So what's your answer to the other part of this, which is the states do you dispute that the states have consented? I know they're not the ones that are being bound, but the first step is, did they consent to follow RLUIPA?
I have to be very precise about this, Your Honor. Yes, the state consented to RLUIPA's plan.